Thank you for attending this webinar today. As some of you might know, I'm Govinder Chambay and I specialise in insolvency at Guildhall Chambers. Now, today's talk is all about directors' duties, or more specifically, the duty provided for under Section 172 of the Companies Act 2006. But just before I begin, there are a couple of housekeeping points from me. If I could ask you to mute yourselves and switch your cameras off, that'd be really helpful. And in terms of questions, if you can pop those in the chat, I'll be sticking around for 5 or 10 minutes once this talk is finished, and I'll be more than happy to field them then. So today's talk is going to be in the context of a very recent case by the Court of Appeal, Saxon Woods Investments Limited and Costa. So just to give you an overview of where I'm going to go, the way I propose to divide this talk up is as follows. I'm going to spend a very short period of time focusing on the historical origins of Section 172. I'll then go on to talk about the principles in Section 172, and we'll then take a look at the Saxon Woods decision a little bit more closely. And lastly, I'll take a look at where that decision now leaves us in terms of principles, practicality, consequences, as well as consideration of the correctness of the decision. Now, a disclaimer is necessary here. Permission to appeal to the Supreme Court has been lodged, so watch this space. Now, Section 172 is the foundational duty which a director owes. So if we start by reminding ourselves firstly of what that provision actually says, it's labelled duty to promote the success of the company, but the way in which that's achieved is a director of a company must act in the way he considers, in good faith, will be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to, and then we get the long list from A to F. Now, I say it's foundational in the sense that breaches of other duties under the Companies Act, for argument's sake, Section 175, that will also typically involve a breach of Section 172. And it almost always appears in any case brought by an office holder against a director. Now, although the provision is actually worded in very simple terms, there's a lot more to it than its apparent simplicity would have us believe. Much ink has been spilt in discussing Section 172, and the Court of Appeal has now spilt a little bit more. Historically, our journey begins with a case called Smith and Fawcett in 1942. Within that case was the earliest expression of a rule which required directors to act in ways which they honestly considered would be in the best interest of the company. And in that case, it was said in the context of directors that they must exercise their discretion bona fide, i.e. honestly, in what they consider, not what a court may consider, is in the interest of the company and not for any collateral purpose. So we fast forward to the 1st of October 2007, which is when Section 172 comes into force. And the whole provision was intended to reflect this enlightened shareholder value approach, which is recommended by the Company Law Review Steering Group. But before we got to Saxon Woods, it's useful to see where we'd gotten up to in terms of our understanding of Section 172. These, in terms of the key principles, are where we were, and now they still apply, but as we'll go on to see, they've just been added to. Section 172 is not about whether the act or omission is in fact in the interests of the company, nor is it about whether the court might have acted differently. No, it's concerned with whether a director honestly believed that their act or omission was in the interests of the company. The issue concerns the state of the director's mind. It is, as the provision envisages, a subjective test. Now, sometimes the case law makes reference to the reasonableness of a belief, but it's important to remember that that is not the application of an objective test. So one particular cited quotation is from a case called Regent Crest, which says, "The question is not whether, viewed objectively by the court, the particular act or omission which is challenged was in fact in the interests of the company. Still less is the question of whether the court, had it been in the position of the director at the relevant time, might have acted differently. Rather, the question is whether the director honestly believed that his act or omission was in the interests of the company. The issue is as to the director's state of mind. No doubt, where it is clear that the act or omission under challenge resulted in substantial detriment to the company, the director will have a harder task of persuading the court that he honestly believed it to be in the company's interest. But that doesn't detract from the subjective nature of the test. So really what the court's saying is that it's more a reflection of a director failing to persuade a court that he had an honest belief, rather than it being the existence of an objective test. But as always, there are carve-outs and there are exceptions. The court can apply an objective test when it's considering whether a director has breached Section 172. The objective test considers whether an intelligent and honest person in the position of a director could have reasonably believed that the transaction or the act or omission was for the benefit of the company. And in terms of when that objective test will apply, it's when there's no evidence of any actual consideration of the best interests of the company by the director. 2, where a very material interest is unreasonably overlooked and not taken into account. Now, some commentators suggest that where the decision is perverse or irrational, that also counts as a ground for saying that an objective test should be applied. But a recent case rather came down quite hard on that principle by saying, in my view, a number of Client Earth submissions conflated irrationality and good faith, treating them as interchangeable concepts. One such example was a citation of Mortimer and company directors as authority for the proposition that if we can prove irrationality, we can establish breach. That is how we put the case. But I do not think that is correct. So far as Section 172 is concerned, irrationality is part of the mix when the court is assessing the evidential question of whether or not the directors acted in good faith, but it cannot stand as a ground of breach on its own. There's no clear authority that it does, and anyway, in the context of commercial decision-making, cuts across the well-established principle explained by Lord Wilberforce that there is no appeal on merits from management decisions to courts of law. Nor will courts of law assume to act as a kind of supervisory board over decisions within the powers of management honestly arrived at. So that's where we were before the decision in Saxon Woods. So starting point is subjective, and there are circumstances whereby the court can apply an objective test. So far so good. Now in Saxon Woods, our factual pattern is this. Saxon Woods Investments Limited was a minority shareholder in a company called Spring Media Investments Limited, in other words, the company. Mr. Francesco Costa was the company's chairman and, in an indirect way, the company's controlling shareholder. Now, it was alleged that he breached a shareholders' agreement requiring all parties to act in good faith to achieve an exit, namely the sale of the company's share capital or its business or its assets by the end of 2019. Now, the company resolved in 2018 that it would hire Jefferies LLC to commence that exit process. But what actually happened, and a key finding of fact, was that the actual instructions given to Jefferies were to find investor interest of any kind in the company rather than to procure an exit. And what Mr. Costa did, essentially, was that he believed delaying an exit could secure a higher price, but in so doing, he misled the board. And so what the court said was this. Mr. Costa and Mr. Uberoy were therefore the only people in a position to know both about the scope of Jefferies' mandate and about the company's obligations under 6.2, and therefore to realise that what Jefferies were engaged in was absolutely not working in good faith towards an exit no later than 31st of December 2019. In giving their fellow directors a different impression, they misled the board. Mr. Costa cannot therefore rely on the argument that it was the board who caused the company to breach its obligations, since the board's decisions in the matter were the result of the fact that he had misled it. This was all in the context of an unfair prejudice petition, but of course, at first instance, Mr. Costa was found not to have acted in breach of Section 172. Now, this is where we see application of the subjective test that I talked about earlier, because the judge said, Mr. Costa's position is that he reasonably believed that it was in the best interest of the company's shareholders for it not to comply with the requirements of Clause 6.2, i.e. the exit provision, on the timetable that it specified, on the basis that a considerably higher value might be obtained for them by delaying the process. He knew perfectly well that at least some of the shareholders disagreed with this and felt that their interest would be best served by complying with the Clause 6.2 timetable. He also perceived that his personal interests as a shareholder were best served by delay. More importantly, he ensured that it was him and him alone who controlled the company's actions in this regard, such that he was not merely in a position to recommend a course of action, but to ensure that that course of action was in fact pursued. However, I do not believe that it was his intention by doing this actively to either injure the company or any investor, and this is quite a key part. I think his state of mind might be summarised as, they wouldn't like it now if they knew, but they will thank me in the long run. Put another way, I think Mr. Costa did sincerely believe that he was acting in the best interests of the company and its investors. So, no breach of Section 172. He honestly believed they wouldn't like it now if they knew, but they'll thank me in the long run. Fast forward to the decision of the Court of Appeal. And the Court of Appeal decided that no, Mr. Costa had acted in breach of Section 172, and some of the key aspects of their decision are as follows. Good faith connotes and requires honesty, and it would be incoherent for the court to adopt a different test for whether a director has behaved honestly under Section 172 from those cases when we'd be assessing whether a non-fiduciary, i.e. a non-director, has acted honestly. Now, the different test to which the Court of Appeal were alluding was the test for honesty/dishonesty in the well-known case of Ivy and Genting casinos. That laid down the test for whether a person has acted honestly or dishonestly as being twofold. So, firstly, the actual state of the individual's knowledge or belief as to the facts, so this subjective element, and more importantly for our purposes, the objective test is whether the individual's conduct was honest or dishonest by reference to the standards of ordinary and decent people. So, the judge at first instance was said to be wrong because he focused purely on Mr. Costa's subjective state of mind rather than considering the second limb of the approach in Ivy, namely whether Mr. Costa's conduct in reliance on his belief was objectively honest by the standards of ordinary and decent people. So what the court at first instance failed to do, so saith the Court of Appeal, was to assess whether deceiving the board was objectively honest by reference to the standards of ordinary and decent people. Now, one of the arguments raised was that, hold on, when we go back to Section 172, the location of the words in good faith means that it's only the consideration given by the director of which course is most likely to promote the success of the company that needs to be honest. In other words, the actual conduct of the director in reliance on that belief isn't subject to any requirement of honesty. And as was candidly accepted, that's effectively a way of saying the ends will justify the means. And the Court of Appeal stamped on that pretty hard by saying, well, no, Lord Green's classic statement in Smith and Fawcett was that directors must exercise their discretion bona fide in what they consider is in the interests of the company. That placement of the requirement of bona fide made it clear that it applied to the exercise of discretion, i.e. what the director actually does, rather than just to his consideration of the best interests of the company. If Lord Wolfson's argument was accepted, it would mean that the 2006 Act made a significant change in the law as it was previously understood to be. This is not an approach to interpretation envisaged by Section 170, subsection 4, and we do not accept that such a change could occur by such an opaque drafting mechanism. And instead what the court held was, in our judgment, Section 172 requires a director, in all he does, to act in good faith towards the company, in the way he considers would be most likely to promote the success of the company for the benefit of its members as a whole, and the requirement that the director acts in good faith includes, as a core fiduciary duty, a requirement that the director acts honestly towards the company. Now, just standing back for a moment, you can sort of see that having an honest belief is one thing, but if the way you're going to go about implementing that belief, i.e. through an act that we would typically describe as dishonest, i.e. misleading, that's what the Court of Appeal is really getting at. It's the way you go about it. So when we apply that to the facts of the present case, the finding that Mr. Costa had misled the board could only have led to a finding that he was behaving dishonestly in the way explained by Ivy. So what the Court of Appeal said was, that being so, the judge's finding at 202 that Mr. Costa had misled the board and by doing so had concealed from them the fact that he was doing nothing to achieve a sale of the shares before 31st of December 2019 and in fact was doing as much as he could to prevent it, could only have led to a finding that he was behaving dishonestly in the way explained in Ivy, and this is important, and hence in breach of his fiduciary duty under Section 172. The finding that Mr. Costa appreciated that his fellow directors and members wouldn't like it now if they knew, but they will thank me in the long run, emphasises rather than negates that dishonesty, and thus the breach of fiduciary duty under Section 172. So we see there a connective between dishonesty and a breach of Section 172, which is important, and I'll come back to that. Deliberately deceiving the board of a company must either always or almost always be inconsistent with a director's duty under Section 172. We do not rule out the possibility of wholly exceptional circumstances where this may not hold good, but nothing of the kind exists in this case. So, just taking a breath for a moment, there's an awful lot to unpack from that decision, but the key points really are these. Section 172 requires a director to act in the way he subjectively considers will be most likely to promote the success of the company for the benefit of its members as a whole, and objectively, honestly, in relation to both his consideration of what would be most likely to promote the success of the company and the exercise of his discretion. Where the director doesn't subjectively consider the position one way or the other, we go back to the objective test that I mentioned at the beginning of this talk, whereby the court asks the question whether an intelligent and honest man in the position of the director concerned could, in the whole of the existing circumstances, have reasonably believed that the transactions were for the benefit of the company. Starting point, I think, here is that if you fail on limb 1, i.e. the subjective test, you then don't get to the question of what ordinary and decent people would have thought. So you fail at the first hurdle. But what that means practically is that in addition to showing that, or pleading out that a director didn't honestly believe that an act or omission was in the best interests of the company, you'd also have to run the alternative line that even if that was what you genuinely believed, 1, his consideration of what will be most likely to promote the success of the company, and 2, your conduct was dishonest by reference to the standards of ordinary and decent people. And it's important we're clear about that, because the Ivy test is binary, at least in terms of the labels it gives. It's either honest or dishonest, and in name it doesn't recognise any grey area. Are you acting honestly or dishonestly? And that seems to be the defining features of the test. Now, in your perhaps standard case involving a director who simply misappropriates a company's property, that's a much easier example of something which would very likely fail under Limb 2 of the Ivy test. Ordinary and decent people would think it's dishonest if you effectively stole money belonging to a company for your own purposes. So on one hand, you could say, well, in reality, the song remains the same. But that's not strictly true, because Section 172, prior to Saxon Woods, was all about asserting the absence of one's honesty. It wasn't asserting the positive existence of another's dishonesty. And whichever way you slice it, that will invariably get people's hackles up, and it raises the stakes. It's the sort of thing which can potentially serve as a sticking point when it comes to negotiations and such like, because we all know that dishonesty is an extremely serious allegation. But there are other ramifications as well, which, at least at first blush, call into question the correctness of the decision, but when viewed properly, I think are actually going to be of more benefit to office holders. So the first heading which we can lump those ramifications under is perhaps the law of unintended consequences. Firstly, the reference to good faith in Section 172 has always been understood as simply another way of saying honesty. But that's in relation to one's belief or their state of mind, as Regent Crest explained. But what the Court of Appeal have done is gone one step further and required the act, i.e. your conduct, to also be honest as well. What's interesting is that the Court of Appeal treat the absence of honesty as necessarily meaning the existence of dishonesty. They treat it in very binary terms, and we know that because of their endorsement of the Ivy test, which again is fairly black and white in terms of the labels it uses. It's honest or dishonest. Now, what that means, standing back, ultimately, is that a positive finding of a breach of 172 must involve a finding of dishonesty. Because take, for instance, a case where a director it's accepted that a director has an honest belief in a given act, and the court then goes on to find that actually, by reference to the standard of ordinary and decent people, that was dishonest. There's been a finding of dishonesty. So otherwise, you would have a case where you'd be saying, I honestly breached a duty which requires a finding of dishonesty on my behalf, which doesn't make particular sense to me. So those unintended consequences are these. Before Saxon Woods, a breach of Section 172, when not alleged to be dishonest, and in circumstances where a company was solvent, was capable of being ratified. Or at the very least, there was room for argument about that. However, we know that a dishonest breach of fiduciary duty is incapable of being ratified. Or at the very least, that's what authority would suggest. So, taking that one step further, it would seem that following Saxon, a breach of Section 172 isn't capable of being ratified. Or at the very least, there is room to have an argument about that. Now, that's going to be of benefit to an office holder, and that's going to be something of a blow to a director. The argument will need to be stress tested properly, but the fact that there's grounds for thinking that is, depending on which side of the fence you're on, is concerning. And if we, in fact, take it another step further, let's think about limitation. A dishonest breach of fiduciary duty, if it's established, doesn't attract any limitation period. Now, that's going to be a huge advantage for an office holder and a correspondingly huge disadvantage for the person defending those sorts of claims. Another heading which calls into question the correctness of the decision might be labelled conceptual confusion. So if we just stick with the idea for just a moment that as a result of Saxon, it's arguable that every breach of Section 172 is a dishonest breach, if we pause there for just a moment, it's never been thought that a breach of Section 172 is to allege a dishonest breach of fiduciary duty. Because cases have been brought which have alleged a breach of 172 without actually having to go on to say, you've been dishonest. What we're saying is, prior to Saxon Woods, is that you didn't have an honest belief. We're not going that further step of saying you were dishonest. And that chimes from a professional obligation perspective, where one has to be very, very careful with the word dishonesty. On the contrary, the notion that every breach of Section 172 will be a dishonest breach isn't an idea which fits particularly comfortably with either case law or statute. Because a dishonest breach of fiduciary duty, according to Subsea and Baltec, requires, at the minimum, an intention on the part of the fiduciary to pursue a particular course of action, knowing or being recklessly indifferent to whether that action will injure the interests of those to whom the fiduciary duties are owed. Now, the sheer reference to a dishonest breach of duty points squarely away to the existence of breaches of duty which are not dishonest. It indicates that such a thing exists, and that in turn points away from the idea that every breach of Section 172 is a dishonest breach. And again, going back to the Limitation Act, the fact that we have a carve-out for fraudulent, in other words, dishonest breaches of fiduciary duty, again implies the existence of breaches of duty which are not deserving of being called dishonest. And I suppose another way of looking at it is, if we strip it back even further, Section 172 is all about the absence of honesty, not the presence of dishonesty. The duty under Section 172 is not a duty to not act dishonestly, at least not in name. That's how it was typically understood prior to Saxon Woods. And lastly, I talked earlier about there being very limited exceptions to the subjective nature of the test. But the decision in Saxon Woods means that an objective test will now always apply if a director is able to persuade a court that he subjectively believed his act or omission was in the best interests of the company. Now that seems to be somewhat outside the relevant ambit of Section 172, bearing in mind that ultimately it was a provision which, at its heart, the issue was the state of the director's mind. Indeed, Section 172 was focused on a person's state of mind. The act was less important, and the nature of the act or omission would ultimately inform whether or not the director was believed as to whether they held an honest belief or not. So we're going back to an example I gave earlier about an act which causes significant detriment. And so what the Court of Appeal have done, at least in one sense, has recognised that the scope of the focus should include not just the state of one's mind, but now also the act itself. But of course, the act was almost, you might say, of secondary importance to the primary issue of the person's state of mind. So, for instance, in the simple case of misappropriation of company money, there's an act, and you can't have honestly believed that it was in the best interest of the company to simply withdraw huge sums of money and spend it on a fancy holiday. That there wasn't any difficulty there. We'd be looking at the nature of the act and saying, well, because it's an act of a certain nature, you can't possibly have had an honest belief that you were acting in the best interest of the company. So whilst that might seem like a wide extension of Section 172, it's not really, because it does sit comfortably with Smith and Fawcett, which talks about the importance of not only what you believe, but also what you do. And it's understandable, I think, in Saxon Woods, because ultimately what the Court of Appeal is saying is that even if you have an honest belief, you still have to be honest about the way you go about implementing it. I suppose the overarching question, though, is did we need to enter that world? I don't have any difficulty per se with the idea that the relevant act or omission must itself be honest, because that would flow from the requirement that it be supported by an honest belief. It's perfectly possible to say that the extent to which a given act is improper makes it very hard for a court to accept that it was supported by an honest belief. As I say, the Court of Appeal accepted that deliberately deceiving the board of a company must either always or almost always be inconsistent with the director's duty under Section 172. We don't rule out the possibility of wholly exceptional circumstances where this may not hold good, but nothing of the kind exists in this case. And of course that logic would flow in the case of a director who simply misappropriates money. And one wonders whether that might have been the neater solution, rather than subjecting the actual act or omission to an entirely new test. It might have just been easier to say, well, you can't honestly have believed that you were acting in the best interests of the company by deceiving the board. But staying with the decision as it is, which of course we must, pending if and when the Supreme Court say anything about it, the decision is actually a blessing in some ways because it gives office holders 2 bites at the cherry. And the reason I say that is because Limb 2 of the Ivy test, i.e. whether it's honest by reference to the standards of ordinary and decent people, doesn't apply if a director does not genuinely, from a subjective perspective, believe that it was appropriate for a company to take a particular act. They'll still be in breach of Section 172, even if ordinary and decent people may have thought that it was appropriate, because he hasn't acted in the way he subjectively considers will be most likely to promote the success of the company for the benefit of its members as a whole, even if he could honestly have concluded that it was. It's just a black letter straight breach of Section 172. But the objective limb will apply if the court is persuaded that the director has satisfied the subjective test. So in terms of having 2 bites at the cherry, the way that looks practically is your first limb of your argument is that you didn't genuinely hold a given belief. You can't honestly have believed that. But even if, Mr. Director, you did, ordinary and decent people would consider it dishonest. So, for instance, consider a director who honestly believes a very, very risky investment is in the best interest of the company. The investment fails and it causes significant detriment to the company. Now, before Saxon Woods came along, what you'd be saying is that you can't have honestly believed that the investment was in the best interest of the company just by reference to the sheer detriment that was caused. So that we're going back to that Regent Crest line of thinking, which is that you're going to have a harder job of persuading me that you honestly believe that when I look at the harm that's actually been caused. But now, in addition to saying those sorts of things, you can also possibly get round the risk of an adverse finding by saying that even if, Mr. Director, you did believe that, ordinary and decent people would still consider it dishonest to try and put it all on the line by entering the investment. Now, there is, of course, room for argument on that because it's always going to depend on the facts. But you can see on the flip side how it might be asked, well, why would ordinary and decent people consider entering the investment to be dishonest? All they were trying to do was benefit the company. But I suppose the option is there for it to go either way. And it's also important that we don't look at this in a vacuum because we've also got other duties, such as Section 174, which of course will involve their own extensive factual inquiry. Now, another heading is false equivalence. And this is what I find particularly interesting. The Court of Appeal's decision implies a line of thinking, at least by reference to the outcome, that the absence of honesty implies the existence of dishonesty. And I ask, is that a fair assumption to make? Is it accurate? For the Court of Appeal, there is no grey area in the labels that we use, and that is questionable because Typically understood, the question in regards to section 172 is whether there's an absence of honesty, not the presence of dishonesty. Negligence is not a good example of how the absence of honesty doesn't equate to the existence of dishonesty, because negligence is all about competence, not bona fides. Now, reckless indifference is a legal basis for asserting dishonesty. Authority for that is sub C. The problem with that is, not caring is not being dishonest. You can be entirely honest and uncaring. Harm and whether acts are improper, they're not useful guides either. You can cause harm and behave improperly without being dishonest. So, using a really simple example, a boy who throws a brick through a neighbour's window causes harm and damage. He's not dishonest. He's just caused damage. He becomes dishonest when he denies knowing who broke the window when asked by his mother. So for the same reason, improper isn't a complete metric either. All dishonesty is improper, but not all acts which are improper amount to dishonesty. In the case of misappropriation of a company's property, the act itself is dishonest. It's effectively stealing. That act is a combination of being improper and harmful. And there are grey areas, because the Supreme Court in Ivey said this: although the great majority of cheating will involve something which the ordinary person would describe as dishonest, this is not invariably so. When, as it often will, the cheating involves deception of the other party, it will usually be easy to describe what was done as dishonest. It is, however, perfectly clear that in ordinary language, cheating need not involve deception. The runner who trips up one of his opponents is unquestionably cheating, but it is doubtful that such misbehaviour would ordinarily attract the epithet of dishonest. The stable lad who starves the favourite of water for a day and then gives him 2 buckets of water to drink just before the race so that he's much slower than normal is also cheating. But there is no deception unless one manufactures an altogether artificial representation to the world at large that the horse has been prepared to run at his fastest, and by themselves it is by no means clear that these actions would be termed dishonesty. Similar questions could no doubt be asked about the taking of performance-enhancing drugs, about the over-application of a magnet to a fruit machine, deliberate time-wasting in many forms of game, or about upsetting the card table to force a redeal when loss seems unavoidable, never mind sneaking a look at one's opponent's cards. Now, just off the bat, I think there are probably lots of people that would describe all of those types of behaviours as being very dishonest. But one can see that there is room for grey area thinking when it comes to this concept of the absence of honesty must necessarily imply the existence of dishonesty. And I suppose in a company context, of course, one wonders whether really what the Court of Appeal were getting at was propriety, perhaps as opposed to honesty and dishonesty. And one can still square it with the fact that this company is a separate legal entity and you're not being clean with it, you're not being straightforward with it. And we've got duties to self-report. So what's effectively happened here is that we've opened the door towards exploring a grey area, and that grey area, one might argue, didn't need to be opened when the test was looking for the absence of one thing, not the presence of another. But even though there is a potential grey area, in practice, as I say, it's a blessing really, because let's suppose you have a director who enters a risky investment, again, which they privately consider will more likely than not fail, but they also hope it's going to work because it's going to allow the company to live another day, as it were. Now, with the strict wording of Section 172, it could certainly be argued that he didn't act in the way he honestly considered would be most likely to promote the success of the company. He thought it was going to fail. That's going to be enough under Section 172, following Saxon, without you then having to ask whether the director was dishonest. But if he had persuaded the court that he did honestly believe that it was in the best interest of the company, and then the objective tests applied, it's going to depend on the facts, of course, in relation to whether on the material, ordinary and decent people could have concluded it was in the best interest of the company. But I think in those circumstances, you can see how a court might be more inclined towards getting to a place of saying a breach of Section 172, because we're ultimately dealing contextually with an action that has caused significant harm and damage to a company and its creditors. So again, let's consider the example of a case where a director innocently transfers a company asset away at an undervalue. Putting to one side your TUV claim, where do you stand with the Section 172 point? If the director persuades the court that they honestly believed that it was in the best interest of the company, would objectively an ordinary and decent person consider that conduct to be dishonest? Now, you can see how there might be interesting arguments deployed by saying, well, it's dishonest because in the sense of being a fiduciary steward of the company's property, you've acted improperly and caused the company harm. But as I said earlier, not all acts which are improper are dishonest. Not all harm which is caused has dishonesty at its core or indeed its root. So it will depend on the facts. But as I say, I think in practice and in reality, I suspect a court's going to be loath to really want to enter too much into the realm of moral philosophy. If the act's caused harm and damage to a company or its creditors, it's going to be keen to fashion a finding that the director concerned has been dishonest. So it begs the question, what space does First Subsea and Baltec now occupy? Well, it would seem that for breaches, all other breaches of directors' duties, barring Section 172, it remains good. And we may not need them, those grounds in respect to 172, because if it's right that to breach it is necessarily a dishonest breach of fiduciary duty, you wouldn't necessarily need to go down, one might argue, the route of showing reckless indifference or a conscious intent to injure, albeit if the evidence is there, you'd say it anyway. But just conceptually, it now seems as though we've got two ways of assessing whether there's been a dishonest breach of fiduciary duty, which depends on the duty which is broken, which at first blush feels messy and it feels wrong. So overall, if anybody feels as a result of the talk that we're in a slightly better position if you're acting for an office holder and in a slightly more difficult position when it comes to directors, you're probably not alone in thinking that. So that's what I wanted to say about Saxon Woods, and as I mentioned at the beginning of this talk, I'm happy to field any questions you have. We've still got a bit of time. So by all means, please do pop them in the chat and I'll try and deal with them as best I can. But more importantly, thank you very, very much for attending the webinar. So I've got one question from Uchi Akali. I hope I'm pronouncing that correctly. Can I summarise the position between the Fawcett case and the Saxon Wood? So yeah, so the key point is where we are now is Section 172 requires a director to act in the way he subjectively considers would be most likely to promote the success of the company for the benefit of its members as a whole, and objectively, honestly, in relation to both, one, his consideration of what would be most likely to promote the success of the company, and two, the exercise of his discretion. Where the director did not subjectively consider the position one way or the other, the court will apply an objective test and consider whether an intelligent and honest person in the position of the director concerned could, in the whole of the existing circumstances, have reasonably believed that the transactions were for the benefit of the company. So hopefully, Uche, that addresses both where we were in terms of Fawcett and where we are now as a result of Saxon Wood.